listras brancas, uma estrela solitária ou uma letra isolada seguramente não são marcas tradicionais registráveis. As listras brancas e a estrela não apresentam originalidade alguma e fazem parte de milhares ou milhões de marcas figurativas mundo afora. Conceder direitos exclusivos sobre o uso de uma letra do alfabeto seria tão absurdo que possivelmente ninguém até hoje tenha tentado obtê-los. Sobre uma cor, ainda que o computador possa produzi-las em milhões de nuances, também parece absurdo vetar completamente seu uso a quem quer que seja. Contudo, tudo isso pode ser visto por outro ângulo se as listras, a estrela, a letra ou a cor forem impressas de uma maneira claramente original e distintiva, sempre nas mesmas proporções e posições relativas no design de um produto ou de sua embalagem. Não é difícil depreender do enunciado que os exemplos acima foram todos extraídos do mundo dos calçados, onde esse tipo de símbolo distintivo se tornou particularmente usual. Mas, se puxarmos da memória, encontraremos muitos outros produtos que empregam mecanismos semelhantes para sinalizar sua procedência e diferenciação. Essa categoria de imagens que sinalizam diferenciação não por sua forma, cor ou textura em si mesmas, mas pela posição relativa em que são aplicadas aos produtos ou embalagens, são denominadas marcas de posição. O INPI lançou consulta pública sobre esse tema, fato que deve ser comemorado por romper com a longa permanência de diretrizes de exame que apenas recomendavam conceder direito aos sinais visualmente perceptíveis que apresentavam distintividade em si mesmos. Este painel discute as marcas de posição e o tema da distintividade das marcas de uma maneira mais geral.
Good morning everyone. It is a great pleasure to welcome you all, the panelists, Mrs. Joana Siqueira, and the participants of this discussion panel. My name is Fernanda Magalhães, and I'm responsible for the marketing law and entertainment law, and I'm a coordinator of the Sports Rights Commission, and I'll be the moderator for this panel today to discuss the regulation of the position marks by the BPTO. And we have different professionals from the area here. As we know, the production position marks, they are known all over the world, United States, Canada, and Argentina, just to mention an example next or closer to us. We will see how important this step is to cover all these issues and the so-called non-traditional trademarks, and they're extremely important in trademarks for sports, the communication with the consumers, and we recognize in these elements how important the product is, and also some legal strategies in general. It is a great pleasure to introduce to you our panelists that will cover different perspectives regarding the law, the trademark law, and the non-traditional trademarks as well, and the representation itself that the BPTO will communicate soon. First, Mr. André Balussier, he is the trademark director in BPTO, and he has graduated from the Federal University of Rio de Janeiro, and he is in the BPTO for a long time, and he's also in the attorney's office. And he has been in several positions in litigation, consultancy, and he has been the general attorney as well. In January 2017, he became the director of trademarks in the BPTO, and as of 2019, he's been replacing the president of the BPTO when it's necessary.
customs, police forces and authorities, investigations and raid actions, stop fake domain names in the portfolio. Also, the IP portfolio management and risk assessment regarding product names, communication and merchandise materials, protection of key styles, preparing evidence and folders and country regional reports in relation to enforcement matters, as well as the definition and management of the group's privacy policy and binding corporate rules, supervising the implementation of these policies globally. Then our guest, Lori Medding, partner and chair of Porters and Bradley LLP's intellectual property group, as well as its trademark subgroup. Lori helps clients protect and enforce their intellectual property throughout the world with a focus on driving revenue and maximizing the value of the company's trademarks and copyrights while combating loss in value and interference with the business caused by counterfeits and trademark squatting. Lori's experience in global portfolio management and cross-border enforcement efforts benefit her clients, which span from a variety of industries, ranging from consumer product categories, including toys, bicycles, and clothing, to industrial and commercial products, including construction equipment, software and insurance and financial industry, to food, beverage, restaurant sector, and a wider variety of service sectors. With all clients, Lori's primary goal is to understand the business and find solutions to legal challenges that meet the company's goals and objectives. Her experienced approach and successful results highlight Lori's dedication to providing her clients with tremendous value and outstanding service. Lori also helps clients find counterfeit goods produced and sold worldwide with a particular focus in China. Lori received her JD from Marquette University Law School and her BA from University of Wisconsin-Madison. Mudo novamente para português para apresentar a nossa debatedora de hoje, doutora Joana Siqueira.
Now,
Com mais
our
de 20 anos de
debater,
experiência em
Joana
propriedade industrial,
Siqueira,
Joana é
more than
advogada,
30
sócia
years
do
of
escritório Montana Pimenta
experience,
Machado Vieira de Mello e uma das
she
responsáveis
is
pela
in
área de
the
marcas de
firm,
escritório.
the law
Joana é
firm,
responsável pelo portfólio
Montana
de marcas
Pimenta, and
internacionais e
she's
participa
responsible
ativamente em
for the
organizações
International
mundiais de PI, como
Trademarks
INTA, a BIP
Office,
e ECTA.
and she has
Atualmente é
been working
presidente da
in
Comissão de
several
Marcas da
bodies
ABIP e
related to
coordenadora
trademarks, and she's the coordinator of the Diversity Committee. With this brief introduction, I would like to welcome you all again. Welcome, Lori and Javier. Please, I'll now give the floor to André for the initial presentation. Good morning, everyone. Good morning, Fernanda, all participants. Good morning, Xavier and Lori. It is a great pleasure and a joy to be here once again in this ABPI Congress. It's a dear association to me. From all associations, ABPI, ASPI, and all, they are very dear to me. And I do believe in a very close relationship, and it's really critical. I always say how critical is the participation of associations for the work of the BPTO, our INPI. We need our users, and this relationship is really critical. Unfortunately, we are still in this mandatory format exclusively. What we expect, well, I expect at least that in the next Congress, that we will not be limited to this exclusive virtual format. And it is really important that we have that because it allows the participation of a larger audience that can follow the ABPI congresses, regardless of where they are. Sometimes I joke about it because in the beginning, I would say more important, well, it was still a seminar and it has become a congress, an international congress. I used to say that more important than the congress itself would be the conviviality and the networking that we had. So it was so rich to see all the plenaries, the panels, the table topics, and really they have become so sophisticated that sometimes it's really hard to choose from one panel or the other which one you'd like to attend to, because one is more interesting than the other. So it's really difficult. We have to keep the Congress going for 2 weeks so that we can participate in all the panels. Well, once I've said that, what I'm going to tell you, well, I have more than 37 years of experience in the public service, the 32 first years in the ABPI attorney's office, and in the last years in the marketing director's office. And throughout these years, participating in conferences, lectures, and other events, I don't remember experiencing something so, let's say, anticlimax or frustrating as the experience that I'm living right now, that I'm going to present to you right now. When I accepted the invitation to ABPI, and it's been a few months, we thought that everything would be settled by this time. All the decisions, the administrative rules would be defined, everything would be final and decided upon. But unfortunately, we still depend on one final meeting that is scheduled to happen next week. Therefore, if the Congress, if I'm not mistaken, if it had happened or if it would happen in October, as we had in 2015, that we had at the same time the ABPI Congress in the city of Rio de Janeiro, we would have everything ready to go and we could discuss in more details the directives that we are trying to regulate the position marks with them. But we still need this final meeting where we will analyze or have the final analysis from all the public consultations that we had, the final expert opinion. Our specialized counseling office will provide that, and all the adjustments to our records. We need to draft this technical expert opinion, and we will define that soon. All of that is done in the CPAPD scope. It is the permanent committee for guidelines improvement for examination. It has been introduced many years ago, and we started to have remote CPAPD, both for industrial design and CPAPs for geographic sources. And we have defined in these committees the subject matters that will need a more detailed interpretation of the legislation, everything that is going to introduce in our manual. This will be defined in the CPAPD, this committee. We have the DIRMA director, the president, the general coordinator, Gerson Ferreira, the three DIRMA general director, and we'll have the coordinator of one of the support coordinators or coordinations in the marketing department, not only to the definition of the judicial pathways, or also from the knowledge management service. I must confess that I'm old. I cannot share at all. I can speak, but I cannot share anything. So I have to use a few cheat hats that I have here. I have two cell phones here so that I can check my information. I really apologize for the possible frustration that I'm not allowed to discuss in more details these examination guidelines because they are not closed yet. And I would not like to discuss or debate something that is not settled yet. So my goal, I believe, that it will be a summary. I'm the nightmare of the moderators of any event. Until next week, we had a very interesting event on the DIRMA operation during the pandemics. And at a certain point, it was coordinated by my dear friend Paulo Parentes and Fabiano Ribeira da Rocha. And I thought that I had a lot of time, and I was warned that my time was over and I had to close. But I believe that this time I will try, and I believe that this time I can respect the time. So my idea is that since I will not be able to move into or to go into a deeper analysis. And right now, I would like to make our office, our marketing director's office available. If you like, and even ABPI, we have already, we would have discuss in more details the guidelines that can be launched. And then I would like to give you some history to see how we can regulate the position marks. This is an old claim of the users, and the initial studies on this subject, they started in 2014 and 2017.
I became director in January 2017, and there was a new structure created in 2016 where DIRMA comprised not only trademarks but also industrial designs and geographical locations. A few months later, in 2017, I had a draft. It was a good piece of work, I must say, but it's still a draft because it's rather different from what we had today. But in any case, a draft of guidelines because we were aiming to implement guidelines, and it was back in 2017. And there is an anecdote to tell you. It looks like a joke because, you know, when you tell this story about the cousin of the parrot and so on. But in any case, the friend of the husband of a former colleague of mine who was a civil servant or is a civil servant. I don't know. I don't even know if he's alive. It's such an old thing that happened. But this man said something which I find amazing. He said that when it comes to public service, nothing is so urgent that it cannot wait 6 months more. So nothing in the public service is so urgent that it cannot wait 6 months longer. And you know, I agree with this statement. When I was working at the General Prosecutor's Office, it was quite common to have lawyers from the administrative branch asking to speed up lawsuits and cases, and they were always in a rush. Everything changed, of course, and currently the Brazilian BPTO only works with online suits. But back then, when this story I'm telling you happened, we had the physical files, the physical suits, and you know that when I analyzed these cases, the paper, I could see that the lawsuit had been filed 2 years before. So can you imagine? A suit was filed 2 years and a half before, and then the lawyers, the administrative lawyers, came to me in such a rush, saying that they needed an urgent decision. And I was always wondering, but I mean, it's been 2 years and a half, and now you come with an urgent matter. But there is this issue of the urgency, definitely. And then going back to 2017, we had the first draft of guidelines, but we hadn't actually discussed them internally. And it only happened at the end of 2019. And you know why? It is no secret that in 2017, 2018, and 2019, our division was focusing most of our efforts in fighting against the backlog, the trademark backlog, which is gigantic in Brazil. In January 2017, in order to examine an application, it took 5 years and 4 months. And the examination of an application without an opposition took 2 years and a half. Little by little, we managed to reduce this term, and now we have 1 year to examine applications. And this is the result of a lot of efforts that have been undertaken. So this occupied most of our energy, and this is why we haven't discussed the guidelines as of 2017. And the backlog is a real problem, and it's also it's a problem to have a very long term to examine the applications, but it's also a problem when it happens very swiftly, because if you take only 6 months to examine an application, I don't think this is enough, because you can receive oppositions or it can be challenged later on. But in any way, our division made an extraordinary work in reducing the backlog, and as a consequence, Brazil adhered to Madrid Protocol that entered into force in Brazil in July 2019. It was actually ratified in July, and it came into force in October. Anyway, when we approached the fourth quarter of 2019, we resumed the discussion regarding the guidelines. And the drafting of these guidelines was based on positional trademarks related requirements, research that had been carried out, literature research referring to non-traditional trademarks, because it has been explained the positional trademark is a subtype of non-traditional brands. Also, some studies carried out by the Brazilian BPTO's examiners, and some training that they followed with the support of a Norwegian law firm. Also, these guidelines were drafted based on a study that we carried out regarding international standards, especially in Switzerland, United Kingdom, Portugal, and Japan. And then after this work, we had 9 meetings where we discussed the guidelines. It all led to the launch of Strategic Initiative 1.5 by the Brazilian BPTO, which aims at modernizing our framework, our brand-related framework, and more specifically, the publication of procedures for registering position trademarks as foreseen to September 2020, September 2021. Of course, that I wish we had already published the guidelines, but in any case, probably they will be published next September. So after the drafting, after the study and the meetings, we had a set of guidelines and a document, and then this document was subject to a public consultation that took place between 13 April and 12 June 2021, as usual. As a result of the public consultation, we had valuable contributions. In total, we had 105 contributions that were submitted from 7 users, 7 entities that I can mention in here because I really would like to value their contributions. Leandro Moreira, Masato Inomiya, law firm, the Special Commission for Intellectual Property from the Brazilian Bar Association. As usual, we had contributions from ABPI, ABPI. They always contribute a lot. Daniel Largo from Daniel Lawyers, also from the International Trademark Association, the Brazilian Bar Association of the City of São Paulo, and Vilara Coelho Law Firm. We carried out an assessment of all contributions that have been submitted to us. And some of these contributions have been accepted and integrated our guidelines, and part of them have not been taken into consideration, but we justified every acceptance and refusal. That's part of our procedure. Whenever we have contributions being submitted to our office, we assess each suggestion and we accept some of them. We do not accept, but we always justify our acceptance or refusal, and it was not different this time. Oh, yes. Out of all contributions, and again, 105 contributions, many of them were similar, of course, but out of 105 contributions, one called our attention. I'm sorry, because, you know, the only advantage of home office working is being able to smoke. So one of the contributions, as I was saying, referred to how the Brazilian PDO would examine position trademark applications in case of refusal. If there is a refusal, okay. If it's accepted, okay, it is granted. But in case it is denied, in case of a refusal. So there was a question. When we accept, we use the Article 122 that in a nutshell explains what are registrable trademarks. You know, distinctive signs that are visually perceptible. So the Brazilian PTO does not register olfactive and other types of trademarks that are not visually perceptible, which is not the case of course, positional trademarks. So we have never had any type of resistance, but it was difficult to register. But when it comes to position trademarks, in case there is a refusal to grant patent rights to a position trademark, it does not fall into Article 124 of intellectual property legislation in force in Brazil. Because as it happens with traditional trademarks, we can deny an application based on the conditions set forth in such article. So we did this public consultation to know whether we could use Article 124 in order to deny the request for a position trademark application. So can we use one condition that is applied to traditional trademarks or to position trademarks? And some questions have been raised because there were concerns that there might be decisions issued not being grounded specifically in a piece of legislation designed for this purpose. You have Article 124, as I mentioned, but we could combine Article 124 with Article 122 and the guidelines that will be issued. So this was the object of a consultation. The Federal Prosecutor's Office analyzed the content of our public consultation, and it was accepted. At the time, I told the chief prosecutor that they had to accept our consultation because for years we've been doing the same things when it comes to processing application requests of highly renowned trademarks, when we examine registration requests of appellation régionale, and when it comes to industrial design requests as well. So of course that we cannot have only one article that comprises all this. And for the geographical appellations, it is the same. So when it comes to highly renowned and appellation géographique, the examination of requests should be grounded on the guidelines to be issued by the Brazilian BPTO, and the idea was to act alike when it comes to examining position trademark requests. So as we were saying, where do we find ourselves? As you know, we are a little bit late, as you know, but I told you already about what happens in the public service in any case. Now in August, we are doing the final analysis of the contributions that have been submitted under the scope of the public consultation. So we have a decree where we tried to include all possibilities that might arise in the examination of a registration. So we are analyzing the contributions that have been submitted under the scope of the public consultation after the review of the guidelines, and we are also doing the final revision of the procedural standards that have been drafted. What are the next steps? We are now about to launch the guidelines. We are operating together with DIRMA, CEPAP, and we plan to publish the guidelines until the end of next September. We will have a last meeting at the end of August. And the forecast is to have them published on 21 September. And after that, we will have to adapt the systems to the examination of position trademark application requests. And this is going to be carried out by the Information Technology Division at the Brazilian BPTO. And you know what? Such an implementation, we don't know when it's going to happen, because it includes generating the request formulation, the issuance of the certificate, and the creation of the IP database. The requests can be filed via 3D forms. We don't have a specific form for position trademarks. However, the examination, the processing shall not take place until we have the IT system implemented. And this is because there is a lack of IT resources at the Brazilian PTO, not only when it comes to position trademarks, but I mean, for other trademarks as well. This is a problem, actually, because until short ago, the IT coordinator mentioned that the USPTO, they have 600 staff working in IT. I almost cried, you know. I don't know. I think it is 60 times more than the number of staff we have working with IT. Of course, USPTO is much larger than the Brazilian PTO, but not 6 times greater or bigger. So we don't really know when the final implementation shall take place when it comes to the processing of the application requests. And I'm sorry, I cannot go into further details because we are still waiting for the final review of the guidelines. But definitely we are going to have the conversion of some requests. In any case, the examination and the processes rely on the implementation of an IT systems. Sorry, Mr. Balussier, we have lots of questions that are being sent by the audience and you have actually answered some of them, but the questions will be made at the very end. So if you can wrap up, because we are going to have Xavier who's going. Oh my God, I'm so sorry, Fernanda. Oh my God, you know, I just realized that I've probably exceeded my time. No, it's okay. You've respected the time that was assigned to you, but we're going to have other speakers who are going to present. No, thank you very much for the opportunity. And just 2 pieces of information. So yes, next week we are gonna have CPAP, the CPAP meeting, and then we are gonna have the necessary decisions that are going to be taken. And on 21 September, We are probably going to publish the decree so that we can launch the guidelines at the end of September. And we do not intend to amend the date. It's going to be 21 September. We're going to publish the guidelines. Thank you, Fernanda. Thank you, dear colleagues. It was a great opportunity. I'm deeply sorry not to give you more details. And it was actually a pleasure to present the work we've been carrying out. Thank you for your attention. So now I'd like to give the floor to Xavier, who is going.
Doutora André, tenho certeza que temos perguntas ainda nessa linha. Então,
Mr.
por favor,
André, please stay with us because we're going to have questions at the end of the session. Of course, unless I have some technical glitches here with the internet, I'm going to be here, you know.
Desde ontem à noite está ventando terrivelmente
there
em
is a
Copacabana,
very
continua
strong
ventando.
wind
Eu
here
entrei,
in
era
Rio
para
de
ter entrado antes,
Janeiro.
entrei quase
I'm
em cima, já
in
começando,
Copacabana
e tenho
right
sérios
now, and
receio,
I
não estava
was
conseguindo me
worried
conectar.
about
Se eu por
my
acaso
internet
cair,
connection. So
se
if
por
I
acaso eu
disappear,
cair, deixo logo,
that's because there was
que
a
a
problem
diretoria fica à
with
disposição para no
my
futuro
internet
eventualmente
connection. In any
responder a
case, we
quaisquer questões.
remain at your
Tá bom, muito obrigada.
disposal.
Se precisar voltar também
Thank you, of
sem
course.
câmera, sua
But
participação
you know,
é primordial. Então, fica o
Claro.
convite
if you
para
can stay with
qualquer
us
forma de
because
acesso
your
nesse
presence
momento é
is
importante.
really important
Xavier,
and valuable to
please,
our
if you
panel.
may share
Xavier,
your screen, I'll introduce you again.
Thank
Can you hear
you.
us?
Hello, everyone. Thank you, André, for the presentation. I'm glad to hear that the weather is not very good in Rio, because I was desperate to go in Rio to participate to the conference, but I was not able to. And the weather is really gray today in Paris, so I'm glad to hear it's the same for you. A little bit more agreeable for me, and I have less regret not to be able to go to Brazil for next time.
May I ask you to put everybody see on full screen? Is it working well? Just so to make sure the logistics, I guess so, right? Yeah. All right. Thank you very much. Here we go. I think we got it.
I'm going to present you a brief overview of the Christian Louboutin Red Soul trademark, which is very often quoted as a non-traditional trademark that will be a reference for law to evolve, and it's I think it would be interesting for you to see what we have done globally. And I will make a little focus on Brazil, where we are still hoping for the trademark to go through. So the Red Soul trademark, for the ones who don't know what is it exactly, this is the picture on the left of the screen. So we have this trademark registered in about 50 jurisdictions worldwide. It's listed on the screen. So our main markets were the first one that we target with this trademark registration, because we were willing to support the business and to make sure that we would keep this exclusive sign to our products. So the first one was registered in the United States in 2007, the first one of this version of the Red Soul trademark. So this trademark is really the best combo we came out with. Before, we had two other versions of the trademark that were either a picture of a red outsole or a design outsole in red. So this one is really the best. Why? Because no matter if the trademark regulation in all these countries allow the registration of position mark, color mark, figurative mark, design mark, whatever is the category that is allowed, we can manage to get the registration to go through with such trademark application. So the trademark consists of the red color. It's a specific shade of red color that is applied to a specific area on the product, meaning here the outsole of a shoe and the heel shoe. So with this representation and this definition of the trademark, we managed to get over a lot of first negative reaction from the offices, and because it was clear that our trademark was clear, understandable, and it was distinctive for all these trademark examiners in these 50 jurisdictions. So now I will present you what exactly happened in the Americas. So as I said, the first trademark registered was in the US. Why the US? Because in the US is our biggest market. So that was very important for us to secure such key IP rights in such key markets. The trademark was registered based on acquired distinctiveness or acquired secondary meaning. So we had to, like in the old days, in 2007, it was still the case, bring boxes of pieces of evidence to the trademark office and a sample of the outsole. And we managed to get the trademark go through in about 2.5 years. Then we start to, of course, to enforce this trademark. And it was very efficient because after several lawsuits launched in the USA between 2010 and 2016, we were able to really clean the market. And now you only have a few infringers that we can find from time to time. Because we had, of course, we had the YSL case, but we had other court cases in which the decisions were very positive. And as soon as you start to get positive decision from the court, then infringers tend to agree on strong undertakings as soon as you sue them, or even just after sending a cease and desist letter. We are also collaborating with the US Customs that are quite efficient because they have seized more than 100,000 pairs of red-sole shoes, lookalike shoes, since 2010. So it was really key for us to enforce this trademark, and again, it did protect our key brand, which is the red sole for our key markets. Then we had the trademark registered in Canada as well, also in Panama, and in both these countries, the trademark was registered as being distinctive per se, meaning that the trademark office, based on the evidence that we present to them, and because the trademark law was allowing that, confirmed that the fact to apply the red color on the outsole of a heel shoe was very uncommon and was significantly diverting from the common practice on the market. Then they just decide to agree on the registration of this trademark, which is the best scenario for us, of course, because it's the easiest one. Then we decided to file a trademark in Mexico, and Mexico is a very great achievement because we were able to first get the trademark registration based on acquired distinctiveness. But not only that, in April this year, the Mexican Trademark Office also issued a decision declaring that the red sole is a well-known trademark in Mexico. So it will bring us to the next level, and we will be able to enforce more and more efficiently our trademark. We already managed to clean the market significantly in just a few years. because a lot of infringers, again, prefer to sign undertakings rather than to go to court. So very efficient program of protection of the red sole trademark in Americas. But there is a but. It's about Brazil, because we filed the application in 2009 and the trademark application is still pending. And of course, with the presentation of André Balussier, I understand, I already had some information that it's a very lengthy process for these new guidelines to go through, and hopefully it will be the case very soon. What I can say is that we are monitoring the market, and we had some issue in the past. We were able to put pressure on these infringers by sending cease and desist letter or using our good relationship with B2C or social media platform, where we did find some infringing goods being sold. But it's not, of course, it's not enough. And we have recently discovered a new target, and this target, after stopping for a while its infringing activities, has now resumed these activities. So we will now need to explore other possibilities, and going to court is one of them. But of course, the situation is very frustrating for us, and we are hopeful that we will soon get a good news from the Brazilian Trademark Office. And we are hopeful because during this lengthy process and many meetings that we had, when we discussed the evidence that we were showing to the examiner, we had the understanding that it was not a problem on the principle. It seems that the examination people, examiners in the Brazilian Trademark Office were okay to register the trademark. They did consider it was distinctive and registrable. So it's just a matter of getting these guidelines, because they need such guidelines to be able to agree on this trademark. So I am hopeful that it will happen very soon. And on our side, it is interesting to note that the red sole trademark has been quoted by Superior Court of Justice in Brazil as a trademark that could be protected amongst also Coca-Cola or Toblerone chocolate bar. So we can see that there is awareness of the red sole trademark in Brazil, and there are some willingness to register it, but we need these guidelines. So hopefully it will happen very soon. And on a side note about Brazil, we would like to emphasize on the fact that we are also working with the customs, and the Santos Customs, we have to thank them for that, are quite active. And in 2020, they seized more than 4,000 counterfeited products being imported in Brazil. And amongst them, of course, you had products bearing the red sole trademark. Of course, the seizure was not made on the red sole trademark basis, but on other trademarks that were on the product. But it shows that as soon as you get a trademark registration, it becomes, of course, much easier to protect your rights and protect your client and customers from counterfeiting goods. After America, I want to quickly overview also what happened in Asia Pacific for us with key example. As you will see, we have managed to register the trademark in Australia, Singapore, Malaysia, Philippines, and most of them, meaning Australia, Singapore, and Malaysia, the trademark
has been registered based on acquired secondary meaning. So in each of these instances, we had again to bring boxes of pieces of evidence to demonstrate that we had acquired such secondary meaning. But in each and every cases, it took between 2 and 4 years to get the trademark application being granted, which is more or less the not very surprising. It's what we experiment in most of the countries. So in all these countries, if we take Australia, the market is very clean. So we only find very few products, and then it's quite okay. In Singapore, we as soon as we got the trademark registration, we decided to launch a zero tolerance policy, and we had a very efficient collaboration with the police forces, the customs, and also we filed several actions in courts, and the courts are quite effective. It's very fast proceedings that manage to get very efficient result quite swiftly. Malaysia, we have launched also several red action. We have sent cease and desist letter. Same in the Philippines, and in all these markets, the infringers, as soon as they understand that you're not going to go away, let them go away with any infringing act, they decide to stop copying your product, and they would be okay to sign undertakings. Also, you can have in some of these countries, you can have also a publication in the press. So it's very efficient to bring the awareness about your trademark to the general public. Asia Pacific, we also had the trademark registered in Vietnam, Indonesia, and Macau. Vietnam, it was a very long process to get the registration. Several meetings were necessary. Many pieces of evidence has to be shown, and at the end, we managed to get the trademark registration, and it was a strong collaboration with the trademark office, because they were keen to register the trademark, but they were struggling with the idea of the position mark. So we had to explain what was the trademark, and at the end we managed to use the category that is not the position mark, but anyway it was fine. They decide that we would benefit from the design trademark category, so it's okay for us as long as we can enforce it. And since then, we managed to enforce this trademark on a few occasions, even in court. And so far, with very positive results, we managed to shut down production in Vietnam that was being sent in Italy, and the other way around, actually. So it was very efficient. Indonesia, very tough country when you want to enforce your IP rights. But we managed to get very positive result by cooperating with the authorities, even if it's very complicated, because you have several divisions of the trademark office that you have to involve to launch any redaction. But when you manage to do it, it's quite efficient, and the infringer will simply agree for all the infringing good to be seized. they will be fine, and you can get public apology in the press, which is always good, again, to bring more awareness to your trademark. Macau was quite easy because it was possible to register the trademark as being distinctive per se. The acquired distinctiveness was not necessary, and the trademark examiner, based on the evidence that we show, realized that, agree that the red color applied to the outsole of each shoe is not something common. Usually the outsole are brown, beige, or black, and not red, and so they did consider that our trademark was distinctive and should be registered as distinctive per se. Then I can give you a quick update on the Europe. Sorry, I'm going very fast, but I know that we have limited time, so I want to present everything.
You're fine, you're fine. You're good with time.
Okay, so Europe, another key market for us, of course, and the first trademark which was registered in Europe was in the UK, again because in Europe, UK was and still actually our biggest market. So that's why we start with UK. It's a principle for my team when we have to implement a program to protect our trademarks worldwide. Of course, we will focus first on the key market, commercially speaking. So in UK, very efficient program with the authorities, custom, trading standards. They are very keen to help when they can. And of course, the judicial system is quite efficient because it's so expensive to litigate in the UK that when you're sending a cease and desist letters and that you show that you're ready to go to court, the other parties will most of the time decide to settle right away. Sometimes you will have to bring an action in court, but it would be settled anyway because no one wants to spend a huge amount of money on such matter. Benelux is a very important area for us because the trademark has been registered since more than 10 years over there, based on being distinctive per se. And why it is important? It's because the trademark was challenged by a big infringer, and the litigation goes until the European Court of Justice because the validity of our trademark was challenged by this infringer. So right now, it's very, I'm very happy to talk about it. But at that time, we were quite stressed because the trademark was challenged. We were in front of the European Court of Justice. And of course, we knew that if the decision was negative for us, it would have a huge impact on all our program. But we were good enough to get a very positive decision. And since this decision, it's amazing to see how all the planet have aligned, because since then we have launched many actions in several countries, and we have used most of the time our EU trademark registration. So in France, Germany, Italy, UK, and in each and every countries, of course, with this decision reinforcing the validity of our trademark, plus the EU IPO also having confirmed on several occasions the validity of the trademark, we have a very strong file. When we launch any action now, the trademark has been tested and tested quite hard, and we have a, if not a bulletproof file, we have a very strong file. So right now we managed to clean some countries such as Germany that were really tough for us, with many infringers selling thousands of infringing goods. And when I said infringing goods, I'm talking about red lookalike shoes, meaning, for example, a pump with a red outsole. And that was something that we were seeing quite a lot at the time. And because we managed to get the trademark registration and then the decision from the ECG, we were able to really clean the market. And it's amazing to see the result that we obtained because of that. So it brings us to our discussion, which is that the importance to get the trademark registration, because without it, it's very difficult to enforce our rights. Before, for example, in Germany, we were having very little results and not very effective. So it's something that I would expect to happen also in Brazil, even if in Brazil, as far as we know, we don't have the same kind of issue. We have a few infringers, but not as much as we had found at that time, for example, in Germany. So I already talked about France. I won't get into the details, just again, the validity of the trademark was challenged in 2017. It was confirmed by the First Instance Court of Paris, and the judgment is definitive. There was no appeal. So right now, same in France, we're quite comfortable, and we can deploy our zero tolerance policy as well in France. Just I think a specific comment because might be of interest for some of the attendees. For the red sole trademark, we use most of the time national trademark application and not WIPO. So we have a few countries in the WIPO where we use the WIPO application for a simple reason. It's because for such difficult trademark and the specific application, when we know that we can take years of proceeding in front of the office to get the trademark going through, we consider that the most efficient way to protect our rights is to go national. And it was, I think, something that we were very happy with, because initially we start with WIPO, but when you start to have, many office action from different offices everywhere, and it becomes very complicated, and it will show every time on your WIPO application, even when you have the WIPO application going through in one country, so it's not that not efficient when you want to enforce your rights at a later stage.
Thank you for sharing that. That's very good insight as to the decision of when to use WIPO. So thank you for bringing that.
You're welcome. So to finish, in few words on Middle East and India. India was the country where we had identified several producers of red sole shoes, and they were selling the goods also in the market. That's why we decided to go first in India, and we were actually at that time also considering to launch our business in India. So it was important to be able to clean the market from this red sole lookalike shoe, because we want to keep it exclusive to Christian Louboutin. So we managed to get this trademark going through. Same as for many countries,
and specifically common law countries, we had acquired distinctiveness to get the registration. In this country, we filed several lawsuits, and we were successful sometimes we had to appeal to get the positive results, but at the end, we always get things right, which is very important. And again, very efficient when you can go to court with a trademark, obviously. And that's something that really helps us for the market to be clean. Kuwait, nothing specific to say. We have the trademark because we had some business over there at that time, and it was distinctive per se. Same for UAE and for Lebanon. But in both countries, since we get the trademark registration, we have put in place a comprehensive program with the authorities. So in Dubai, it's the DED. In Lebanon, it would be the customs and police forces. And we have launched several actions, and we are still conducting action over there because we still have some infringers, but very few compared to the situation before we got the trademark registered. So again, it's key to get this trademark. So I think I have missed, I didn't miss anything. Sorry to have been so quick, but it's already 14 after 3, and Laurie has to talk still. So thank you very much.
Thank you, Xavier. Thank you so much. No, great insights, and we definitely have questions for you on the strategy and the commercial strategies behind all these decisions, but it's great to have the overall challenge of the brand globally. So Laurie, I give you the floor now to share with us the perspectives of Bobcat, your clients, and the other brands that you work with. Excuse me. So without much more delay, go ahead, please.
Great, thank you so much. And it was very interesting to listen to Xavier. That's a great presentation, and I'm a huge fan of the shoes. So it's nice to see all the protection, and it's well deserved. So I'm going to speak a little bit from the perspective of primarily the US, but also one particular client that I work with to manage their global intellectual property. And in particular, for this presentation, of course, their non-traditional trademark, or as we commonly refer to it as in the US as trade dress. So under US jurisprudence, the key aspects of a non-traditional mark or a position mark being deemed to be protectable is that the mark must be non-functional. It can't really help with the use or purpose of the article. It needs to be somewhat arbitrary, and it can't impact the cost or quality of the article. And that's sort of the first hurdle that you must get over. Beyond that, you also need to show that there is some extra meaning associated with it. And so it's generally not going to be viewed as a symbol that's inherently distinctive. So rather, you have to show that the trademark has acquired secondary meaning. To do that, we generally will provide a lot of information. Sometimes if you just demonstrate that the trademark has been in use for a long period of time, that's sufficient, but usually not. Usually it goes beyond that, and showing sort of the market presence by showing evidence of sales, advertising spend, examples of advertising, and then things like awards, customer recognition, things of that sort. Obviously, when it comes to a position mark, it's necessary to show advertising that shows the mark, on the product. And so that can often be easy, but it's also really necessary to have, in many cases, to have advertising that really prominently shows, the position of the trademark. So this is the machine. You can see down here in the corner, it's primarily this machine here that has the protection that we're talking about today. And so the key distinctive elements with this machine are the color of the wheels, the color of the tailgate, and then the color of the body. Also claimed in a number of the registrations is the color of this piece, which is called the cab. And so this color is actually Bobcat orange. It is a custom color that was created by the client, but it's often referred to as an orange red. So it's definitely a different shade than the Louboutin Sol, but it's obviously in the same family. But it's very interesting, and I wanted to comment on this because I am really passionate. Part of why I wanted to participate today is I'm really passionate about the fact that these symbols do function as trademarks. They do function as symbols, and people recognize them. So, you walk down the street and you see a woman wearing a shoe with a red outsole, and you immediately know, oh my gosh, that's that shoe. And you know the source, and you're immediately impressed, and you have an impression of it. And the same goes in a very different way with respect to this machine. If you see this machine in a field or at a construction site, and you can pick it out from a distance, and you know that it is made by this company, which has a very old and reputable history. It's a very high quality product. And so people know it, people want it. And that's why people want to copy it. And that's why we're going through all these efforts, right, to protect so that we can do something about the copying. So the product that's claimed is actually a skid steer loader. And we also have a class 12 registration that covers utility vehicles, which is a very similar vehicle, and the position of the mark is similar, but the function of the machine is a little bit different, and there are some different elements to it. But of course, we don't claim the machine itself. We claim only the colors. And in the drawing, you can see, let's see, here's the drawing. I'll advance ahead. Again, like the Louboutin drawing, there's dotted lines, and that's just simply to show the position of the mark, but that is not claimed. So these are the jurisdictions where the Bobcat mark is filed or registered. In a number of countries, we have two registrations. We have this one that looks like a flag. We call it a color swatch. And it's, in some respects, you might think, oh, it's much broader protection. But when it comes to enforcement, it's frankly not as useful. It's much more useful for customs and other individuals who are maybe not as sophisticated to understand that the positioning is what they can look for and understand, rather than just abstractly three colors. And so the countries where we have the mark registered are these that are listed here. In China, the color swatch is only registered right now, and it was registered before the Chinese trademark law changed. And so now there is a different requirement to make a specific claim in an application that there's actually a place in the application where you can denote that it is a position mark or a dimensional mark, rather than simply a standard mark. And so we have an application pending there that is actually has been refused, and we are on the third level of appeal at this point. We are about to file the third level of appeal. interestingly, and this is actually right now, this is, we're at that stage. And interestingly, some of the, and hopefully I'm just going to say it because it's a group of trademark practitioners, but the Chinese trademark office and courts seem to be having some backlash against the US right now, and have made some comments in their decisions that are suggesting that they just don't like us. So it's a US company, and the opinions being applied, or the analysis and reasoning as for the basis of refusal are not well-founded and not well established. And then there's comments. So that's a little bit frustrating right now, but we're still very hopeful to get that application approved and get that mark registered, because with respect to these goods in particular, but many goods, of course, China tends to be a hot source for goods to be manufactured and then basically sent all around the world. And so we've always kind of taken the approach that if we can have an effective tool for enforcement in China, we will get further, even globally, and we'll have a greater impact globally. So we've invested quite a bit of effort in China. Coming back to this slide, these are just examples of a few of the copy machines that, as you can see, in many respects, they bear a lot of resemblance to the Bobcat machine. Certainly the colors are identical, the placement of the colors are identical, but of course there is no use of Bobcat on the machine or the Bobcat logo. And so really the only mechanism that we may use here is to enforce against these infringers is to assert the positional trademark, the non-traditional trademark. And so in countries where we don't have that registered, it's a huge challenge. Here I talked a little bit about some of the evidence that is relied upon to establish distinctiveness, which I think might be very relevant for Brazil in terms of what tools it might use for, the guidelines for examination. And these are just the categories that were used in China that, most certainly should have been sufficient and have been sufficient in the other countries where registrations have been awarded. But, the high market share, high sales volume, very broad sales scope, and different advertising, and also just commentary by third-party news sources that are talking about the machines and featuring the machines. And then, in this particular case, there's an industry association for construction equipment that publishes its own independent reports about market share and recognition. And so those have also been useful in many countries as well. So one of your neighboring countries to Brazil, in Argentina, we've had significant success with, we have a registration there, and we've had litigation in several cases, and that's been a very good result. And there have been some of the same parties, though, that have infringed in Argentina have also been infringing in Brazil as well. And so it's frustrating when the limitation on the enforcement efforts has to sort of stop at the border and can't flow into some of the other South American countries where the products are traveling to. And so again, we're just very eager to have the means to enforce rights in Brazil, in addition to Argentina, because they are two of the most active countries in terms of sales of our own clients' products, but also the infringing activities. In our case, the Brazilian applications that are pending were filed in 2012, and there are several applications, there is a 2D positional trademark and a 3D positional trademark application. And so it's my understanding that those applications were filed in that fashion in order to sort of take a creative approach to trying to find a way to protect the non-traditional trademark in Brazil, because the lack of well-established legal premise for protection of those marks. And so, that too, not quite as long as the Louboutin filings, but they've been pending for a long time, and we're quite eager to have the law enacted so that we can see those applications mature to registration. So very excited about this opportunity to talk about that today. In China, as I mentioned, we have the little 3-color swatch that is registered, and that has been a useful tool for conducting online takedowns and for sending letters to infringers, some of whom are scared enough that they cooperate, some of whom do not. But where we have limits are, we can't use the registration at customs or for in-person or on-the-ground raid and administrative enforcement actions. So that's why we're seeking for the additional protection there. And the plan is to continue to try to protect the trademark in other countries. Interestingly, in the United States, we have not had a lot of infringing machines, and I believe that's because slightly different customer base than obviously the luxury goods market, but also it really is it has such a long, these machines and this company have such a long, well-established history in the US that there's more interest in and access to authentic equipment, whereas in some developing countries and countries where the machine is not as popular or well-known, interest in having a machine that maybe looks like it but isn't genuine is certainly, but cheaper, is certainly very common. So just for information, these are not clients I work with, but I was part of the non-traditional trademark committee for INTA 2 years ago, and one of our projects was to look at the big five, EU, US, Korea, China, and Japan, and to determine what trademarks, what non-traditional trademarks were registered or have attempted to be registered across those jurisdictions. And these are just an example of a couple of those trademarks. There's, in fact, very few that are registered across the board. And I was actually really surprised and impressed to see how many countries that Xavier, you've registered in. That was really great to see. And, I might have to talk to you offline about it a little bit, maybe. That was really cool. So anyway, I'm fast. That's my presentation today, but I'm happy to answer any questions about the US or the efforts to register the Bobcat trademark rights.
Thank you so much, Lori. Great presentation. I think it shares the strategy, the insights, and the tactic challenges too, right, in enforcing the strategy. So I'll pass the baton now to my colleague, Joana Siqueira, for some of the questions. We had several questions from the audience. Joana, please.
Oi, antes de mais nada, eu queria parabenizar todos os palestrantes.
First of all, I'd like to congratulate the speakers for the excellent presentation. It made my job very easy because most of the questions have already been answered. So I'd like to thank the excellent moderation of my friend Fernanda. And it's an honor to be here with you in this panel. This topic, the regulation of position mark in Brazil, is here to modernize our system following this international trend, as Laura has presented and Xavier as well. It is really important to have in mind that as a consequence of this regulation, it will avoid that unnecessary issues come to our courts. So it is a win-win situation. Unfortunately, we have very little time. I would have many questions. I will have to control myself here, not to go into the regulation itself that has been presented by our BPTO that has already been mentioned. Our BPTO has participated, represented by Rafael Atabi. I also participated on that, but I'm going to control myself in order not to go into much detail on the regulation. I was really happy with this news that we have a date already set for the publication. And I think this is a great victory for all of us. I understand that this implementation is going to take a little bit longer due to all the facts that we have already discussed. Regarding the implementation itself, one point that I'm concerned, and I would like to hear Andre on that, is that if you are taking into account the trademark legacy that have already been filed, that they identify themselves as position marks, and they can require in this operation, they can require this position. I know that they are corporate trademarks that have not been decided upon yet. They will have the opportunity to change and become a position mark. Do you feel comfortable to talk about that, Andre? I'm sorry, Joanna, I think Andre is no longer with us. Andre, can you hear us? He ran away. He ran away. Yeah, when we said that there was many questions. Oh, I'm joking. Let's change questions then. Yeah. So if Andre comes up, we can ask him again. But now,
Can I, sorry, Joanna, can I have one comment on the criteria to find such application? I don't know if we would have the opportunity to change to a position mark, but on our side, speaking about Louboutin, what is really important for us is to have the opportunity to bring to the examiner the relevant piece of evidence, and if we were to change the trademark application today to a new one, then we would have to review again the criteria. Are we fulfilling the criteria, etc.? And I have one comment on that. Is about what Laurie just mentioned. Volume of sales, your market share, etc. And it's very important to use such criteria with regard to the relevant market, because on many occasions when we file our trademark, we had to take a lot of time explaining to the examiner that we are a niche market and exclusive products. So you cannot look at our figures like you would look at figures of a huge company. And some of them are really struggling to apply the criteria with regard to the relevant relevant market. And that's something that should be included in the guidelines, because we have seen in some countries, specifically in Asia, that they were really by the book. And if it's not written expressly that you can, use this criteria in a different way because you're on a niche market, they will always look for, they want to see billions of sales. They want to see that you have 80% of market share, etc. And this is unreachable for many companies. Mm-hmm. Very important to put this into perspective. If you include that in your guidelines and in the criteria, it's very important to have something about it. Otherwise, you will prevent a lot of companies to be able to register such trademark.
It's a very important point, Xavier, and it has been discussed during the analysis of this regulation intended by the Trademark Office. But thank you so much for your input. Very, very helpful. So I'll move forward with the question to Laurie and Xavier regarding the business impact of the legal protection of position trademarks. And I would like to know how, that I'm going to read the question again. Can you share with us the business impact that the legal protection of position trademark may offer? And do you have any specific case to share? Go ahead. Who want to go first? Perhaps Laurie, Xavier just talked a little bit.
So like I was just saying, you know, in the examples of some of the infringing machines that I showed you, there is no Bobcat on the machine. There's no, you know, they have their little cat head logo. That's not on the machine. And so the only way to take steps is to have a position trademark to enforce. The way these often come to our attention on the ground, particularly in countries like Brazil and other South American countries, is Bobcat has a dealer network. And so they have dealers all around the world that sell equipment. And they have exclusive agreements with Bobcat to be the exclusive distributor in a particular geographic area. And so Bobcat provides guidelines on pricing for them, and also, of course, sells the product to the dealer for a wholesale price. And so then the dealer, like any business, has their margin, and they sell the product for a little bit of a higher price, whatever that may be. What happens when there is an infringing machine, many times they are of a lower quality, they are more cheaply made, and they are not as reliable. But at the time of purchase, perhaps that isn't noticed or cared about because the machine is a lot cheaper. And so it undercuts the price for the original equipment, the Bobcat authentic equipment that is being sold by the authorized dealer. And so it takes customers. So if I am a landscaping company and I want a Bobcat machine to help lift dirt at a work site, I am going to say, well, let's see, I can buy the Bobcat machine for $30,000, or I can buy this one that kind of looks like it for $15,000. And so I'm going to get the $15,000 one, even if it's not as good of quality. And then they don't buy the one from the dealer. So it's market share. It's taking away customers. It's taking away business that is otherwise should be Bobcats. The other thing it does, as I was saying, the brand itself is very valuable. And the company has a very high reputation. They are on the higher end in their market. Their machines do cost much more than a lot of their competitor machines, other brands. And so, you know, even though it's a piece of construction equipment, the brand still has cachet, and there's something that people really, you know, associate with when they buy that brand. And so by diluting the brand with a lesser quality machine, it harms the brand. And so it makes it more difficult for the company overall to continue to have the high value in the brand, which, you know, that's very detrimental, both in terms of, you know, the prices that can be commanded for the product and the overall value of the company.
Thank you, Laurie. Xavier?
I fully agree with Laurie on this topic. I don't have much to add to what she just said, which is so true. So we have a slightly different maybe opinion on because we are not distributed in the same way. So for us, the harm is more direct because most of our products are distributed through our own network of boutique. So if we encounter such counterfeit goods and infringing goods, and that they would obviously damage the brand reputation, and also this iconic brand, which is the Red Soul trademark, which is really easy to spot on a shoe. If you can see it on other shoes, cheaper shoes, then it really hurts the image of the product itself, and you know, the high quality image of the product. So it's something that you really have to defend, because we are a luxury company, so our products are very expensive, and they have to stay exclusive. Of course, it's not only about the brand, because there is also the craftsmanship, there is the design, which are very creative, and all that is bringing value to this good. But still, the brand and the Red Soul trademark has shown that it's very powerful for the company, and that's why we have enforced it very strongly worldwide, and specifically in our strongest market, commercially speaking, because also it's something that is very important for the future of the company. And you know, it's interesting to go back to the origin of this trademark, which was, you know, first placed on a product in 1992, end of 1992, and it was a test by Christian Louboutin himself. But then he didn't realize that it was something so important. He was looking at it in a creative way, but very quickly it's the customer and the public who react to this sign and say, "Wow, it's great, and it's your shoes. You're the Red Soul brand, etc., etc." That's when he realized that there was something really powerful with this sign that needs to be protected further and need to be value for the company. And I agree with Laurie. As a company which is valued based on its IP, and of course craftsmanship, but IP is key. We definitely need to be able to enforce such iconic trademark for the future of the company. Not doing it will be, of course, very detrimental to us.
Thank you, Xavier and Laurie. And I do have a final question that I really wished on that to be here as well. And I'm going to move forward in English because I'll need your inputs again, Xavier and Laurie. So do you consider possible to the position trademark protection be fully applied once you do not simultaneously have the regulation for secondary meaning?
My phone is open, so I will start.
Okay.
It's okay for you, Laurie. But for us, it's very simple. If we look at what we have done in the past 12 years, approximately 15 years now. Yes, times fly. Being able to rely on secondary meaning did allow us to register the trademark in more countries than if it was not existing. For example, in several countries, it was simply impossible to register a position mark or color mark without demonstrating the secondary meaning. But on the contrary, it was not possible to register this trademark if you didn't show that, meaning that it's the only option. So I don't know what will be the decision of the Brazilian Trademark Office, but it's either they only open this position mark to company that will be able to demonstrate acquired secondary meaning, then it's obviously that you need it, or they will open such possibility to both inherently distinctive trademark and when you have acquired secondary meaning. I think if you want to have the full scope and the full possibility for brand owners to be able to find such trademark, it would be good to have both, because it's true that when you have to rely on secondary meaning, it's a very lengthy process and it's much more work for the legal team and the company, because then you have to follow a lot of criteria. It's very convenient when it's possible to rely on the fact that it's inherently distinctive. Of course, you have to define what you mean by that, but obviously, most of the time it's when you significantly diverting from the common practice in the market, and that should be enough most of the time. But I don't know what will be the decision of the Brazilian Trademark Office. So I hope I was.
Vamos torcer para o próximo passo ser a regulamentação do secondary meaning, que sem
Let's hope that the secondary meaning shall be the next step, that they shall be the object of future guidelines. Lori?
I agree, and I was just going to add that you know, in terms of inherent distinctiveness, I think that, you know, if the office does not want to look at all the different pieces of evidence and proof, perhaps it could simply look at what the competitors, the valid competitors in the industry are doing to show that it is out of the ordinary and it is unique and it is, you know, an exclusive use as compared with one that is commonplace. And that would be a more straightforward means of doing it. But I'm afraid my only hesitation with encouraging that you do it that way is that I think that it doesn't give the total picture, which I think is often necessary to fully evaluate whether protection is appropriate or not. Because as we all know, I mean, a trademark protection is extremely valuable because it can last for so long and it can be used to exclude others. So I always try to think of things like, I don't want to be on the other end of it where I'm representing a client that then all of a sudden is excluded from doing something because a competitor improperly obtained an exclusive right in something that is that should be used by all. And so it's, I guess that wouldn't happen if the office was looking at the competitive landscape, but it just seems that having more data points and more evidence available would create a fuller picture.
Thank you, Lori. I'm moving back to Portuguese now. É uma pena o André não estar presente, né?
Unfortunately, André is no longer present to have his opinion, and because he can speak on behalf of the Brazilian BPTO, and he mentioned that there is an entire process underway. And they also are assessing the contributions submitted through the public consultation, but I think it's worrisome indeed. And we should have a correlation between both trademarks. And André said that once things are released and put in place, he could come back and talk to us again. But just to express my concern, Article 1 of the proposed regulation by the Brazilian BPTO mentions that the positional trademark requires an inherent distinctiveness. So if you require inherent distinctiveness, in a way, you limit the protection that is obtained by means of secondary meaning. And also, this is required by law. So in a way, I'm worried. You know, as I said, I was going to control myself, because there is a public consultation on the way and we don't have so much time in our panel, but we can think about it later on. And I will try and talk to André so that he can clarify some of these points. But we should also celebrate the fact that we have a date for the publication that is going to be made by the Brazilian BPTO. So shortly we'll be able to say Brazil has a regulation in force for position trademarks. Thank you, Joanna. You're right to make this provocation. We had several questions to André. The audience sent lots of questions, but unfortunately, he's no longer connected. But the discussion was very fruitful, very interesting, and he gave us some good news, such as the fact that the guidelines are about to be released. So trying to end with a positive note, I'm quite happy that we're going to have the regulation published soon.
Important and valuable to us. I think we could carry on this conversation easily for another hour. I had tons of questions, to be honest, about the business, which I always love to ask. But unfortunately, we're already a little bit over our time. So I appreciate. Agradeço a todos pelas perguntas. Conseguimos submeter
Thank you
algumas
very
aqui,
much
mas
for your
infelizmente não
questions.
todas a
We
doutora
were
André.
able to address some of them, but André is not present. So in a future occasion, in a future event, we might ask him all the remaining questions. So thank you once again. Have a great day, you all. Bye.
Bye.